This conference will now be recorded.
2 minutes early.
Oh, this time.
Oh, since when I didn't say you had fun. Morning.
Good morning.
That's helpful. Thank you.
They're not, and we'll just.
I'll go inside, not a problem.
Thank you.
Oh, great, thank you so much.
No, it's not. All right, I got 10 o'clock on my phone, so we'll go ahead and call the code enforcement hearing. We're already today, February 15th, for the town of Ocean Ridge to order. It's 10 a.m. First order of business is to swear in anyone who's going to be testifying on any of the items on today's agenda. So if you could stand and raise your right hands for me. Anybody who's here, are you all respondents for one of the cases? No, just listening? Okay, perfect. Sir, do you swear from to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Next on the agenda is adoption of the February 1st, 2022 minutes. I reviewed those and I'll hereby adopt those. And I'll turn it over to the town to start with the first case.
Thank you, Your Honor. The first case we're going to call this morning is case number 2022-005, Ronald Kerrigan, is respondent. The property address at issue is actually a Kerrigan subdivision. This was a property that was made into 2 parcels, subdivided, replatted, and part of that subdivision is requirement that Mr. Kerrigan make some improvements to the area, including the right of way. And what this case is about is whether to complete those improvements as required by the code. We have the town building official here to testify on behalf of the town. The violation 6412 deals with having all improvements done within 12 months. 6415 refers to a letter of credit, which we've also put the property owner on notice of, that if the project's not completed, the town will be pulling on the letter of credit to complete the work.
Good morning, thank you, Your Honor. So, as the attorney stated, this project is for improvements. The 2 lots that were subdivided. The permit has expired, and the town commission did give an extension till the 31st of January, which that time frame has also expired. My most recent visit to this location was last week, Thursday, and the work is incomplete. There is still a section of the road, a circle turnaround that needs to be paved. There's also a missing wall and a fence. We're still requiring sub-permits for those, and as of today, they still have not submitted the revisions or permits to include these life safety elements of the project. So
So those items are not even permitted as of today.
as of today, they're not.
Okay.
And, we've had site meetings as far back as November of last year, where the contractor, engineer, or town engineer, or public works department all agreed that these items needed to be resolved. And as of today, few months, later, still have not been completed.
Okay, and I see, let me just look at the rest of the exhibits in
Your Honor, in the package that we provided, the original notice of violation was sent out to notify the property owner of the deadline of January 31st of this year to complete the project. We re-noticed so that he had the 10 days notice minimum for a hearing. So he was re-noticed, and that's the amended notice of violation that's in your package. That was certified mail and posting at the subdivision where the permit for the right-of-way improvement currently exists. Also sent certified mail and posted here at Town Hall. I believe the town clerk has also had communications with Mr. Kerrigan regarding this matter.
And is there any further update? Just for the record, nobody's here on behalf of the respondents this morning? Seeing none. What's the most recent correspondence?
I mean, he did say his contractor is gonna submit we're supposed to be getting revisions for the site wall. That was the last correspondence, and he was aware of the hearing, but that was it.
And what is the town speaking in terms of the remedy this morning?
Your Honor, we're seeking 90 days to complete the project and obtain a CO, failing which we'd ask for a fine amount of $250 per day. And the town's costs are $124. One of the challenges with this, Your Honor, is that the two parcels in the subdivision have been sold to third parties. So this would just be a personal lien against Mr. Kerrigan himself, as he's now divested himself of the property.
Okay.
But those property owners can't do anything because the subdivision improvements aren't completed.
Are complete, right? Mr. Guy, do you have photographs in this file?
I don't think there are any.
No, the only photograph I think was of the postings at the very end.
Yeah, I see that, okay.
But that's it.
We
I mean,
have
I
the
do
field
have-
observation reports. Is that something we could?
We can probably.
No, that's okay, I just want to make sure that the record is clear that, so the outstanding items are the circle drive, and then you said a fence and a wall that needs to be permitted?
Yes.
Okay. And those are all on the approved plans for the development, is that correct?
The wall was, but not the fence,
Okay,
because of the height of the wall, safety reasons require that a fence.
so that's the installed, okay. Okay. Okay, so you have good service here, I see signed green card, so I'll find that you have proper notice of this morning's hearing with your amended notice documentation. I'll enter into the record the town's composite exhibit 1. And town attorney, you said 90 days, so
Yes, Your Honor.
that would be,
That's to obtain a CO for the project, complete the project.
okay.
I have a question.
Yes, ma'am.
Calling on the letter of credit, if the project is not done in 90 days, are we able to do that?
Yes,
After completing
and
90
we'll,
days?
since Mr. Kerrigan didn't show up today, we'll go ahead and have to send him that letter via certified mail, which only requires 60-day notice, but we gotta get that going, so.
So is the town okay with a compliance date of May 16th? The 15th falls on a Friday, so 90 days would be May 16th, is that acceptable?
That works.
Okay. Okay, in case 2022-005, I'll find, as I said, good service for this morning's hearing. I'll find based on testimony of town staff and the documents in composite exhibit 1 that the respondent is in fact in violation of section 64-112 and 64-115 for failing to complete improvements in the subdivision within the time previously allowed by the town commission. I'll require the respondent to comply on or before May 16th of 2022, or assessing a fine in the amount of $250 per day, and I'll award the town's administrative costs in the amount of $124 for this morning's hearing, to be payable within 30 days of the date of the order.
And Your Honor, I think just to perhaps in the order reflect that, also if it's not complied within 90 days, the town has authorization to go finish the project if we need to pull a letter of credit.
Yes, that's fine, and just, I'll also have the order reflect that compliance in this matter is issuance of the CO, not just application of building permits or partial completion. And as you said, if a CO is not issued on or before May 16th, the town will be authorized to pull on the letter of credit to complete the required work. Okay.
Okay, Your Honor, the next case we have on today's agenda is case 2022-003. Property owner is Summit Ocean Ridge LLC. The property address is 6600 North Ocean Boulevard 1 in the town of Ocean Ridge. This case involves work without permits and then continuation of work after a stop work order was issued. This involves sort of two separate types of work going on. One was performing interior demolition, and the other one was the re-roof. We do have this town's building official, Durante Guy, present to testify. The town is going to look for a bifurcated order in this case. The recommendation is 30 days to obtain the re-roof permit or a fine of $250 per day, and 30 days to obtain the interior demolition permit or $250 per day. And the town's costs are $319. Have the costs changed at all with the resurface?
And I'm sorry, the fine amount on the first,
$250,
okay, so 30 days on both and 250 on both.
yes.
Mr. Guy, do you have anything additional?
No, Your Honor.
Your Honor, in the town's exhibit, we have proof of service was the initial notice of violation, which was issued in January of 2020. There is also the amended notice to ensure that they receive more than 10 days notice for the hearing. The interior demolition, the town was alerted to, and you can see from the photographs that it was all interior work, and that's what, and Mr. Guy, you may want to testify to this, caused this initial stop work order to be issued. And then there was a re-roof going on, and that's the second violation, 67-60 for the re-roof after the stop work order was issued. So perhaps if you can give her some background on what you saw and what you did prior to the notice of violation being issued.
Sure. So the town was alerted on January the 7th that there was incessant banging at empty apartments at the location. Officer Robert McAllister and myself went by, and there were not many vehicles parked at the location. We were looking around to see work vehicles of some type, materials, nothing. When we went along the corridor of the building, we immediately noticed there was a lot of drywall dust, and all the doors were closed. So we walked around and we did hear banging. And once we looked, we did observe there were two workers inside one unit, gutting the unit. And once we knocked on the door, they, did say, they were there under orders to do work. We immediately asked them to stop. And we basically looked around and noticed that the drywall trackings went to a few other units. And we also noticed that all those units had various degrees of work being performed. We got the information for the new owners. We understand that the building was recently sold, and we contacted the management company. They claimed to be shocked. They said they had all the documentation and everything ready for permitting, and they were under the assumption that the job was being properly done. So, we gave them notice and said, okay, let's get the permits applied for and issued. They did apply. However, the package was, incomplete, and they were given a list of the shortages, and we're still awaiting resubmittals and a complete package for us to be able to properly review and issue that permit. A few weeks later, we got a call again that this time full-blown work was happening on the roof. And when we turned up, there was trucks with materials and maybe half a dozen guys on the roof. To their credit, they did have safety equipment on the roof. They, put up barriers along the edges for the safety of the workers. They had a kettle boiling with tar, and they were going at it. The gentleman said that they had dropped off the permit the previous day or that morning, and it should be okay. And I said, it's not. You guys need an issued permit to be able to perform this type of work. They subsequently stopped and packed up the material, contacted the new owners again, and said that they claimed that they did not give authority to this company to work, that they gave them permission to leave material at the job site, which is what they claimed, which is not exactly what was happening. So we, started, I eventually got to reviewing that application. And interestingly enough, the reason for the roof, one of the primary reasons, were AC units that were put on the roof sometime in the past that were not properly permitted and were not properly installed. They were installed on wooden blocks, and because of that, the blocks absorbed water. It created dents in the roof, and obviously, over time created roof leaks. So they needed to be removed and properly installed. That was not a part of the initial application, so those documents are still being awaited for proper permitting and engineering of those units to sit on the roof properly in order to correct the roof repairs. So as of today, the permits have not been issued. We're still waiting on corrections to the applications for the interior work and also for the roof.
So is it two different permits that have to be issued?
Yes.
One for the interior renovations and one for the roof?
Yes, two separate permits, two separate contracts.
And the roof has been applied for or not even applied for?
Yes, it did.
So both have been applied for?
They did apply, I believe, the morning or the day before they actually started work. So they dropped off the application and
then went back and thought they could
Right.
proceed with work, okay. And for the record, do we have any respondents here for 6600 North Ocean Boulevard 1? It does not appear we have respondents. So with that, I'll enter, first I'll find that there's good service for this morning's hearing based on the affidavits of posting and the notice documentation in the case file. I'll enter into the record composite exhibit 1. In 30 days, is that the 15th of March? That's during the week. So the 15th of March is okay, town attorney?
Yeah.
Okay, in case 2022-003, I will find that based on the testimony and the evidentiary case file and the photographs in the case file and the testimony of Mr. Guy, that the respondents are in fact in violation of 67-51 and 115.3 under section 67-60 for performing both interior demolitions and re-roof work without approved and issued building permits, and continuing after a stop work order was issued. I will grant the town's requested compliance dates. First, for the interior demolition permit to be issued on or before March 15th of 2022, or a $250 a day fine. And for the re-roof, I'll also require respondents to comply by March 15, 2022, or a fine of $250 per day to start running thereafter. And I'll grant the town's administrative costs for today's hearing in the amount of $319. Again, payable within 30 days.
Thank you. All right, Sarah, the last case we have on today's agenda is property owners, case number is 2022-004. Property owner is Lava Enterprises LLC. The property address is 51 Spanish River Drive in the town of Ocean Ridge. Your Honor, this is a violation due to a failure to maintain a seawall under section 6481, 67-74 that requires it to be maintained in good condition along with landscaping. The citation to 6774 talks about the required improvements that they need to make. So technically the violation of just two sections, 64-81 and 67-174. The town's building official is here to testify, and you have before you the town's case file showing proof of service, proof of ownership, and correspondence.
Thank you, Town Attorney. So this portion of the town is a man-made island. So the barriers between the waterways and the upland areas are protected by seawalls. So if that seawall is not properly maintained, it is a danger to that property. Then to the adjacent lots, that's usually the next progression. They usually start seeing washouts on their property, and obviously for the whole town in general, if one seawall breaks, it's a break in the link that could create a disaster on the island. So I did respond to a complaint, and I was given access to a neighboring property where I was able to see significant washout between the wall and upland. Obviously, there were attempts in the past to patch the area, but it is something consistent. There seems to be some holes, not obvious just by the removal of the soil over time, that something is going on there. So the notice that was given was for them to acquire the services of an engineer to verify the structural integrity of the seawall, and if repairs were needed for the permits to be acquired and the work completed. And then for the appearance standards, once the wall is repaired, then for the area to be restored and regrassed. To date, we do not have a completed permit application. Maybe trying to beat the clock, they submitted just pretty much the application with a few some paperwork, but it wasn't in nowhere complete to the necessary documents that were required to properly review and ultimately issue a permit for seawall repair or replacement. So we are still waiting on that. The contractor did call and said that it was his intention to actually permit the repairs to this wall. And I advised him that this is a code enforcement issue and that the wall is in seemingly a rapid state of deterioration, and that the only way that we could actually stop is unless we have a permit or an evaluation from an engineer. And to date, we have not received that.
And so I'm looking at the photos in here. What is it that water has come over the seawall and it is like washing it out from the back?
So if you notice, the grass will not grow in that area. Also, there's a lot of different type of fill material. There's sand, there's gravel. So what that indicates to me is that there've been constant removal of that material from behind the wall.
And they're backfilling it to keep it up against the seawall.
And I'm just looking at it, but I have to be careful that I have not done an internal investigation. That is why I asked for an engineer to make that evaluation.
Okay.
And we have not gotten that.
But that's what your pictures are reflecting, is that area.
It
where
would
there's
seem like
gravel and-
that's what's happening. There's something abnormal happening at that location, enough to concern the neighbor and, obviously to concern me as well. But, we needed an evaluation. Also, just by, us being contacted by a contractor that says, yes, they're working to do repairs to that wall. But, as of yet, a promise is not the same as an actual permit, a commitment to actually do some work. So
Understood.
we would like to give them a timeline to have this completed, because if it left unattended, then it will be drastic to neighboring properties and all.
Okay, and what is the town seeking?
Your Honor, the town's seeking 30 days for them to obtain an issued permit or submit documentation that establishes that it doesn't need to be repaired.
Correct.
Within 30 days, or face a fine of $100 per day thereafter. The town's costs are $160.
Okay, so that's compliance by March 15th, either by issuance of a town permit or an engineering report that confirms that there's no required improvement to the seawall. Is that correct?
Yes, sir.
The engineer's report would suffice for?
Yes.
Okay. And then for the code section that requires the vegetation, so once they get the permit issued, they still need to plant. So assuming that they have an engineer's report and that nothing further needs to be done, they still have to plant additional plantings. So would the town like to split that or include that in the 30 days?
Yes, Your Honor, we would include that in the 30 days, because if our engineer report is submitted, then they would need to restore the area. And if they got a permit, at the conclusion of the permit, the area would need to be restored.
Okay, so include the landscaping requirement within the 30 days. Okay. And for the record, is the respondent here on behalf of 51 Spanish River Drive? Seeing none, we'll let the record reflect they are not present. And I've looked at the evidentiary case file. You have a signed green card for this morning's hearing, so I'll find that notice is good and sufficient. I will enter the town's composite exhibit 1 into the record. And in case 2022-004, I'll find that based on the evidentiary case file and testimony of the town's building official that the respondents are in fact in violation of section 64-81, 67-74, and 67-174 for failure to maintain the seawall and adhere to the maintenance and appearance standards required by the town code. Now require the respondents to comply with each of those sections on or before March 15th of 2022, and compliance will can either be demonstrated by issuance of a town issued building permit or an engineer's report suggesting, concluding that there are no required improvements to be made or necessary to be made to the seawall and installation of the required landscaping. If compliance is not achieved on or before March 15th, I will have the order reflected a finding on $100 per day will be assessed thereafter, and I'll award the town's administrative costs for this morning's hearing in the amount of $160, again payable within 30 days.
Thank you, Your Honor.
Anything further from the town?
No, Your Honor.
Okay, then we'll adjourn at 10:28.